It's 1:15 in the morning. You just pulled into the Taco Bell drive-thru after a long night out. You're tired. Maybe you had a couple drinks hours ago and thought you were fine to drive. Then the blue lights hit your mirror. The officer walks up and says, "Sir, how much have you had to drink tonight?" Your heart starts racing. Do you answer? Do you explain? Do you try to sound sober? Or do you stay quiet? Because right here, before any field sobriety test, before any breath test, before the handcuffs, most DUI cases start with one thing: the driver talking too much. And that's what makes this situation dangerous for ordinary people. A late-night food run feels harmless, but from an officer's perspective, a Taco Bell parking lot after midnight can look exactly like a DUI hunting ground. Slow driving, wide turns, sitting too long at the menu speaker, missing the curb, delayed reactions, bloodshot eyes from exhaustion. Everything becomes evidence. One sentence can change the entire stop. One joke can become probable cause. One careless admission can follow you into court months later. Every video here could save you from a serious mistake one day. Subscribe now so you don't miss what could protect you. Then share this video and drop your opinion below. I want to hear what you think. So in this video, we're breaking down what officers are actually looking for during a DUI stop, the biggest mistakes drivers make during these encounters, the exact phrases you can use to protect yourself, and how to stay calm without making the situation worse, because the roadside is not where you win your case. The first mistake people make is trying to explain themselves. The officer says, "Where are you coming from tonight?" And the driver immediately starts talking. "Oh, I was just hanging out with friends. I only had 2 beers. I'm just tired. I'm fine to drive." The problem is that officers are trained to observe impairment indicators, and your own words can help build that case. Even saying, "I only had 2 drinks," may be treated as an admission that alcohol was involved, and nervous people tend to keep talking. That's where problems snowball. You might laugh awkwardly, slur because you're tired, mix up details, repeat yourself. All of that can end up in the police report. A calmer response is usually better. You can politely say, "I prefer not to answer questions," or "I'm exercising my right to remain silent." Why does that matter? Because you are not required to narrate your evening for the officer in most situations. Remaining silent limits the amount of evidence you hand over voluntarily. Now, that does not mean refusing lawful commands. You still may need to provide your license, registration, and proof of insurance depending on your state law. You stay calm, you stay respectful, but you stop feeding the investigation. That distinction matters. The second mistake is trying to act sober. People think if they smile more, talk confidently, or joke around, the officer will let them go. Sometimes drivers even overperform. "Officer, I'm totally fine. Watch this." That usually backfires. Officers are trained to look for exaggerated behavior too. Overconfidence can become part of the report, just like nervousness can. And here's another trap. Many people don't realize fatigue can look similar to impairment. If you're exhausted, your speech may slow down. Your eyes may appear red. Your reaction time may be delayed. So when drivers start over-explaining, officers often pay even closer attention. Instead, keep your responses short and calm. If the officer asks, "Have you been drinking tonight?" you do not need to start debating the officer roadside. You can calmly say, "I choose to remain silent." Notice the wording. You are not yelling, you are not arguing, you are clearly invoking your rights. That matters because silence alone can sometimes be interpreted ambiguously. Explicitly stating your intention makes your position clearer. The third mistake involves field sobriety tests. This is where many drivers accidentally help build the case against themselves. An officer might say, "If you've got nothing to hide, step out and do a few quick tests." Now, laws vary by state, and specific circumstances matter. In many places, field sobriety tests are voluntary, but drivers do not often realize that. So, they attempt the tests in a dark parking lot at 2 a.m. while nervous, tired, overweight, injured, elderly, or standing on uneven pavement. Then, every stumble becomes evidence. The officer may ask you to follow a pen with your eyes, walk heel to toe, or stand on one leg. What people miss is this. These tests are designed to gather evidence, not necessarily to clear you. So what can you say? A calm response may sound like this. Officer, on advice of counsel, I do not wish to perform voluntary field sobriety tests. That phrase matters for several reasons. First, it stays respectful. Second, it avoids physical resistance. Third, it clearly communicates that your refusal is intentional and not confusion or aggression. Now, very important legal clarification here. Chemical test laws are different. Many states have implied consent laws tied to breath, blood, or urine testing after arrest. Refusing those tests can sometimes lead to license suspension or other penalties, even if you are never convicted of DUI. That is why viewers should understand there's a major difference between roadside field sobriety exercises and post-arrest chemical testing. The rules can vary significantly depending on the state and the facts of the stop. This is educational information, not personal legal advice. The fourth mistake is consenting to searches when you don't have to. Imagine the officer says, "Mind if I take a look inside the vehicle?" A lot of drivers panic and say yes because they think refusing automatically makes them look guilty. But consent searches are a huge issue in criminal investigations. Once you consent, you may limit your ability to challenge that search later. And remember, officers are often trained to ask in a casual, friendly way. Just trying to clear things up. Won't take long if you've got nothing to hide. But constitutional rights do not disappear because an officer phrases the request politely. A calm response is, "Officer, I do not consent to any searches." That sentence is powerful because it does two things at once. It avoids physical confrontation and it preserves your legal position. Notice what you are not doing. You are not grabbing the steering wheel aggressively. You are not yelling, "You can't search me." You are not insulting the officer. You are simply refusing consent verbally. That's a major difference. Now, if the officer has independent legal authority to search, they may still proceed, depending on the circumstances, but you do not have to voluntarily make it easier. The fifth mistake is trying to fight the entire case on the roadside. This happens constantly. Drivers start arguing law. "You can't pull me over. This is unconstitutional. My cousin's a lawyer." That almost never helps in the moment. The roadside is not a courtroom, and emotional escalation creates risk fast. Officers may interpret aggressive behavior as non-compliance or even a safety concern. Fast movements make situations worse too. Reaching suddenly into pockets, opening doors unexpectedly, digging around the center console without explanation, all of that can increase tension immediately. Instead, narrate your movements calmly. "Officer, my registration is in the glove compartment." Then move slowly. That reduces misunderstandings. If things escalate and you believe the stop is unfair, the safest approach is usually to stay physically compliant while verbally asserting your rights. For example, "I am not resisting, but I do not consent." That wording matters. It communicates nonviolence, it communicates lack of consent, and it avoids physical escalation. If you are arrested, this is where another critical phrase comes in. "I want to speak to a lawyer." Simple, clear, direct. After that, stop talking about the facts of the case. A huge number of DUI prosecutions rely heavily on statements made after arrest. People keep talking in the patrol car, in the holding area, during booking. They think cooperation will talk them out of charges. Usually, it just creates more evidence. And here's something many people do not realize. Officers often continue observing you the entire time. How you walk, how you speak, whether you sway, whether your emotions change rapidly, whether you repeat yourself. Everything may end up documented. That's why calm silence is usually safer than emotional explanations. Now, let's tie all this together. If you ever find yourself in a late-night DUI stop outside a Taco Bell, a gas station, or anywhere else, remember the basic framework. Stay calm, keep your hands visible, comply with lawful commands, do not argue roadside, do not volunteer information, do not consent to searches you do not want, do not try to win the encounter emotionally, and use clear, respectful phrases when necessary. I prefer not to answer questions. I choose to remain silent. Officer, I do not consent to searches. Am I free to go or am I being detained? I want to speak to a lawyer. Every one of those phrases serves a purpose. They help reduce misunderstandings, they help avoid escalation, and they help preserve rights without turning the encounter into a confrontation. But remember, laws vary by state, and DUI investigations are extremely fact-specific. What applies in one jurisdiction may work differently somewhere else. This is educational information, not personal legal advice. And one final point. The safest way to avoid a DUI arrest is simple. Don't drive impaired, because even if charges are later reduced or dismissed, the arrest itself can still cost thousands of dollars, damage your record, affect employment, and create long-term consequences. In the next video, we're breaking down another major police encounter mistake: why saying, "I know my rights" during a traffic stop can actually make officers investigate you harder